Good morning and welcome to the SLW Institute's International IP webinar series. My name is Greg Stark and I am a principal with Schwegman, Lundberg, and Worcester. Today's webinar, Differences Between US and EPO Practice, Part 1, will be presented by Dr. David Keston. David is a UK and European patent attorney in Schwegman's UK office. He has a joint honors degree in theoretical physics and mathematics from the University of St. Andrews and a doctorate in plasma physics from the University of Glasgow for research into equal mass plasmas. David has worked as an examiner in the UK Patent Office, in-house with the legal functions at Siemens and Vodafone Group, and in Tier 1 private practice firms. To submit a question, please feel free to use the Q&A feature on the webinar menu. Thank you for joining us. Now over to David for today's presentation.
Well, how do you do, everybody? And thank you, Greg, for introducing me. I think I'm feeling a slightly larger head already. My EPO practice has been almost 20 years. My US practice has been patchy at best. In my in-house roles, I quite often engaged with fellow and associate US patent attorneys and indeed with agents. And this is where my understanding and knowledge of the US patent practice comes from. It's the extent of my knowledge of the US patent practice as well. So see how much you feel I understand of US practice as I launch into an explanation, which is aimed at explaining how European patent attorneys work from day to day. So I suggest that we take you through a trip on the sort of work that a patent attorney would do in Europe day to day, prosecuting European applications. The reason we wanted to talk about the differences between US practice and that in Europe is because there are actually, while many similarities, a number of differences in the procedures and the culture that operates in the European realm, should we say, in the region. The European Patent Office itself belongs to a convention, the EPC, to which you'll see many references. And that European Patent Convention governs the law of both the EPO, but also, to a greater or lesser extent, the individual national laws in the member states of the EPC. So why talk about the topic and why notice all these differences when they are in some cases rather slight is that knowledge of the differences in the law and the procedure can be essential. It can be essential simply to avoid loss of rights, but also to avoid falling foul of procedures, which is time consuming and for your client consumes his money as well. The last reason, and actually one of the reasons that I was most willing to talk, was because it minimizes misunderstanding. We use the same language and yet we misunderstand some of the terms we're going to use because it's used in a different way when discussing European prosecution and that in the States. So I've illustrated that in the way that we have street signs. The street signs in the UK at a crossing point will most often be a giveaway sign, as you can see, a yield sign. Whereas in the States, the few times I've actually dared to drive on the wrong side of the road, I have seen stop signs appear everywhere. We don't use stop signs except when we think we're going to die. Other than that, we will use a giveaway sign just to remind the driver that there's another road ahead. What I hope to pass on to you today would be to give you context, to perhaps inform people who haven't had day-to-day experience with European prosecution but want to know more, and also to remind those people who already do know what they ought to know or what they need to know about the EPO and the way it operates. And then to suggest things that you might want to do that would help you work with your EPA attorney Just as the US Patent Office has, shall we say, a closed shop that requires the intercession of a US attorney, we too in Europe have the requirement that unless you are the applicant yourself, at some point you will be using a European patent attorney to help you prosecute the case. And finally, there are certain issues that you'll see, you might experience as formalities issues, which I just want to give you perspective on, so that they look quite extreme in some cases, but actually are not intended to do harm. So, with no more ado, I'll go on to the next slide, where I just basically introduce what Europe is. Just to remind you, Europe is not one single country. The European Patent Office is a transnational body, and it represents not just the EU, those countries that are a member of the European Union, but also countries outside the EU. And this is my one opportunity to mention Brexit before I stop, because this list has Switzerland, it has Norway, and until just the end of last month, had the UK as one of the members of the EU, and now we have to add the UK to one of those beyond the EU. That does mean that all of the patent practice that was previously operated stays unchanged post-Brexit, because the EPO and the EPC are not bodies of the EU. In fact, they pre-existed the EU. The EPO provides for the central prosecution and grant of patents and opposition, I'll come to later, and also indeed the possibility of post-grant amendment up to a certain point. There are limitations in what the EPO does in terms of jurisdiction. It does not apply to jurisdiction over disputes, especially in terms of infringement cases. And with the exception of the short-term opposition, it deals with no revocation actions either. I'll remind you that national patent offices would grant national patents alongside of their involvement with the EPO, and they hear the revocation actions for national and EPO granted patents, and likewise the national courts will handle disputes, both enforcement and validity disputes. To remind you then, the states of the European Patent Convention span pretty much in every single nation state within Europe, including some of the very small ones. So I was going to zoom in on some of these states, but countries such as Andorra, the Vatican City, Liechtenstein, and Luxembourg find themselves as treated as the same as Portugal, Spain, France, Italy, and the rest. Also, we include within the EPC member states Turkey. So some people might see that as outside of Europe, as they might also see the states that lie in areas. I'm going to use my mouse here just as a pointer. That we have Morocco and Tunisia and Moldova, and indeed Cambodia lie in a number of states where they have access to the system of the European Patent Convention. So in fact, what we have is 38 automatic states within the European patent application, another couple more extension states. Again, with my mouse, you can see these two former Balkan states where one can extend, that's Bosnia, Herzegovina and Montenegro. And then finally, you have validation states where further agreements are in place, which give them sort of adjunct rights. And it looks like there are certain countries likely to join the validation states, such as Georgia. Now, for the moment, the EU is 27 states without the UK. Prosecuting in in Europe is in many ways very similar to that in the United States. You have a stage where one searches the patent application. forgive me, have a stage where there's a search of the examination, and the EPO has the right to refuse to search inventions that they think are clearly excluded. We'll come to that in a little while, and in fact I'll spend a little bit of time talking about the exclusions since they come often as questions from US associates. The EPO will search only the first invention that they find, and this touches on one of the other issues that comes up more often than not in prosecution of cases where the EPO believes that there is a lack of unity, and where there is a lack of unity, they will effectively refuse to search anything other than the first invention that they see. So a bit like the restriction requirements in the States, but different, as you'll see later. Likewise, in searching, there has been in the past, and maybe some of my, shall we say, more experienced colleagues in the States will remember the case where if you had a regional phase application coming from a PCT application, that could be denied the opportunity to pay further search fees. So you might have to take remedial action, which could be quite expensive. Nowadays, that situation has been ironed out. In fact, that is in the last 5 years, this has been ironed out. So that now whether the application is a European Convention application, which the European Patent Office in its wisdom calls Euro Direct, or one of those regional phase applications, a Euro PCT, the applicant will be given the chance to pay further search fees. It's normally a 2-month deadline to decide whether you want to do that. And if you do pay additional search fees, and indeed if the claims numbers don't exceed 15 and you have, or you pay the excess claims fees for more than those claims, you will have a search of not the first, but also the second and indeed third, fourth and fifth inventions, provided you pay for each one of those searches. After that fact, you will be able to decide what you want to do with that, since you can't prosecute any more than one invention in any more than one application, but at least one has a choice. If, for example, invention 1 looks like it's dead, invention 2 and 3 can be picked up and filed in, and in one case, continue in the current application, in the other in a divisional application, for example. Mentioned divisional applications, this is the only route to having unsearched subject matter protected in Europe. So if matter has not been searched for whatever reason, search fee not paid, it was only ever in the specification and never was part of the claim set, then at some point one will have to file a divisional application in order to protect that subject matter. And that can be somewhat different from the way things work in the States, I understand. You had a brief view of the examination page, but in the next stage after search, and bear in mind that in the recent years, the European Patent Office has been running a system called Bringing Examination and Search Together, or BEST. I love their acronyms. What they now do is they now perform what they call a first examination for compliance with the EPC. And what effectively that is looking at a first substantive examination, which appears most often as a search opinion. Now, if the case was a Euro Direct application, then the search opinion will be that attached to the European search report. If it were, however, from a PCT route, there would be either the written opinion of the International Search Authority, which of course could be from the European Patent Office itself, and or an IPA, an International Preliminary Examination Report, should a demand have been filed in the PCT international phase. And so in either of those cases, that would be treated as the first examination for compliance, even though it's in the latter case, it's the PCT that's supposed to be complied with. The EPC and the PCT are seen as almost equivalent by the European Patent Office, and they will simply look at a concordance between the articles of the EPC and those of the PCT and say, well, if the ISA says this, then we say exactly the same thing unless there's a good reason not to. They might ask for additional objectionable material to be addressed, but the core of any first examination will be referring back to the previous search authority's output. So when I use the word examination report, and this is pretty much common across Europe, what we mean is an office action that requires a response. Now, strictly speaking, in a UK perspective, an examination report would probably be just that, issued by the examining division under Article 94.3. So those of you who have some experience of working with the EPO will have seen a fair few of those. But the more general understanding is that an examination report would also include a communication pursuant to rules 69 or 70, and or one pursuant to rule 161. So rule 161 comes about for ex-PCT, so Euro PCT applications, whereas one can have the other kind of communication in either case, whether it's a case of a Eurodirect or a Euro PCT case, and effectively there the requirement is to look back at what was said in the research opinion, whichever one it was, and then to respond to those objections. That is your first examination report for compliance with the EPC, and I'm emphasizing that simply because the point at which you respond to that is the point at which you have used up your opportunity to make voluntary amendments. So in addition to responding to the issues that have been raised in search opinions, you have the opportunity to make additional voluntary amendments, somewhat like making preliminary amendments in the States, but that facility is extended from the point that a search report has issued to the point at which that first examination for compliance issues. So, I mean, in sum, I note on my slides that the EPO is thus actually closer to the US practice than it used to be, simply because you now find a search report effectively produced along with a substantive set of objections which will need to be responded to. There is, however, still a little gap between the search results being received and the requirement to respond to objections. So one has 6 months or so in which one can observe the search results and yet still not have to respond to something. So that can be quite enough time to see what's going on in the States, for example, and to decide whether to proceed with a parallel prosecution approach, or indeed to allow the two cases to diverge. The other point I wanted to make with examination is that, somewhat similar again to the prosecution process in the US, there is a facility to arrange calls with the examiner. One can even visit in person if one happens to be in one of the particular site where that examiner is. I would say my experience is that can be helpful, but it tends to be if there is a single issue that can be resolved relatively quickly, rather than should we have a general discussion of all of these different issues. That tends to be better to reserve for on the paper discussions, simply because the examiners feel mobbed if an attorney turns up on their door and says, "I want to talk to you." I guess that's much the same as what's happening in the States. There is a formal requirement on the examiner, if that happens, a call or a visit happens, for them to write a report, and then that report becomes part of the public file. But the report can be very minimal in terms of the material that it discusses. Now, the goal, obviously, of examination is to have the examination division reach a communication under Rule 71.3 EPC. Effectively, what that is a division is providing the text that they think is allowable, and we have to approve it as the applicant. Or indeed, we can come back and say we disapprove the text, but we propose a new text with minor and acceptable amendments. And hopefully the examining division looks at that, says, okay, yes, that's what we wanted in the first place. Thanks for pointing out those small typos. However, experience tells me that in many cases, what actually happens is that the examiners do not wish to grant us the patent. What they prefer to do is to say, okay, we have reached impasse. We cannot work out a way forward for you. We can't see that we're making any progress. So in those circumstances, we will invite you to oral proceedings. Now, oral proceedings is a right that every applicant will have, and certainly you will see in any European attorney's work output, the last line of any letter that they write to the EPO will be, oh, and by the way, if we haven't already asked for it, can we please have oral proceedings? So we trigger that right by asking for it in the letter, in an official response. Thus, I don't think I've ever had a case where I've at no point has any request for oral proceedings been made and then seen the division simply refuse. But in principle, it could be that the division will refuse, no oral proceedings requested, the case is dead. Summons issues for oral proceedings, and then this is the closest thing to the final office action process in the US. Here in Europe, the response to the summons is, generally speaking, if there is something that the applicant thinks should be granted, but the examiner is missing the point, is a flurry of responses, or potentially a single response, we call it written submissions, with a number of different possible requests, normally in order of preference. This is what I really want. This is my auxiliary request in case you don't like that one. And in principle, the examiner will look at each one in turn until he finds one that he likes and then says, okay, well, I can grant on that. Because the oral proceedings procedure has been triggered, that means that not just one examiner, but 3 need to review the material that's been sent during this written submissions stage, and they will look at it, and if they see their way to granting the application, they will offer that as allowable text, and one can avoid the need for oral proceedings. That again, in advance of oral proceedings, one can have more than one call with the examiner. One can even try and attend informally and discuss the case with the examiner, but the examiner will be less likely to want to do that in the case of written submissions because the oral proceedings is already scheduled. I've noted here that oral proceedings can now be done as a video conference, but it can also be done in person. I have colleagues who would strongly prefer still to appear in person. However, in extremis and in certain cases, a video conference can be cost effective. And for some clients, it's the only way that they can see to having the case resolved quickly. Oral proceedings themselves are a final affair. If at oral proceedings, a hearing, the examiners, and there are 3, decide that they are still going to refuse the application, they will make a decision that it is refused, and that decision effectively stops the procedure before the examining division. You simply then have to appeal that decision, and the appeal process is something that I'll be talking in more detail in my next webinar, and I'll refer to that a little bit later on. Now, I need to crack on a little bit. The goal, obviously, is grant, and in the European prosecution, there are additional requirements you might not see for the equivalent in the States. There are 3 languages into which there must be claims upon grant. In general, and I think on last accounts, 80% of European applications are filed and prosecuted in English. That means that the claims in English will need to be translated into French and to German, and that's a prerequisite for grant. If you haven't got the translations and the fee being paid, then grant won't happen. The grant having been announced and being published, one has 3 months after the notice of grant has been published to validate in designated states. And as you'll recall, that's sum total of 38 plus, depending on how many extension states you have selected, that you can be validating in. In each case, one has to appoint an address for service in that country, file the translations, because in some cases, full translation of the specification will be required, and there may be fees to be paid, as well as the attorney costs in the local area. Okay, so I've talked for 20 minutes on the general procedure, and hopefully much of that will be very familiar to those of you who see applications day to day, and European applications day to day. You may see a whole selection of different objections in those search opinions and indeed in the examination reports generally. They follow a number of themes. In general, and not particularly unexpectedly, patentability is the main objection that is seen in these cases. And the treatment of patentability is somewhat different in Europe to that in the States. And possibly the most interesting part of this discussion is to talk about those differences. The patentability of an invention starts with the question of what an invention is. The European Patent Convention doesn't help us. It simply says, in passing, it connects the thought of inventions with being in all fields of technology. So that reference to Article 52.1 here reminds us that actually there's no definition for invention, but essentially it has to have something to do with technology. And that governs or guides the policy as to what might not be an invention. So while we don't have the same requirements for patent eligibility as those in the States, you can see some themes appearing. One cannot consider a discovery or a scientific theory or a mathematical method to be an invention, nor can one see an aesthetic creation as an invention. The final two areas are the methods and rules and schemes for performing mental acts, playing games, doing business, and so on. And particularly for programs for computers, these are not considered to be inventions, nor are presentations of information, whether they are methods or actual physical hardware. But, and this is the key helper that the EPC has, that exclusive list, or that list of exclusions, only applies to those things as such. So that if what we're talking about is not just a program for a computer or just presentation of information, then one can escape the trap of being excluded subject matter that is not considered to be an invention at all. Now that's very helpful because one can then escape and move on to the next steps in identifying patentability. But this is where the EPO catches you. So rather than catching you for being not patent eligible, they catch you for being generally not a patented invention. And my experience is they catch you for not being inventive. So rather than identifying it as excluded subject matter, and as the new slides suggest, the invention, if it involves some technical means, it can avoid being trapped by Article 52. Generally speaking, it will be novel because virtually everything that one looks at will have some slight difference over what's happened in the prior art, but the trap will be that it will not be considered to be inventive under the EPO. So many times a computer program might escape patent exclusion only to be deemed not inventive because the computer is a conventional computer, and the means for implementing the invention is, and the technical means is not deemed to be inventive, therefore. In terms of the EPO's approach to inventive step, it's worth reminding that they follow an approach called problem solution. And here, what they're looking for is an identification of differences that are not, or that the invention does not address in the prior art. And then an identification of that problem being whether that problem is technical or not. As we note here, the field of the person who would be concerned with the problem should be identified. And that is another signifier of whether the field is a technical field. And then very often the EPO will simply point to the features that form the invention or that form the claims, and they say, well, these features that are non-technical are entirely disregarded for the purposes of inventive step, because they're deemed to be merely business requirements that the skilled person would be given when he's attempting to solve a technical problem. So if you can find no technical solution, one is not deemed to be inventive. And so that can be the trap. In terms of medical methods, however, we have a slightly different situation. Here, a public policy says that methods of diagnosis, therapy, and surgery are not patentable. And this applies across the EPO, but also across the individual nation states. There's, this is reflected in every nation of the EPC. And here, what actually that means is that rather than having an as such get out, as with business methods or computer programs, one doesn't have that. Now, if a claim includes even one treatment step or surgical step, it's not allowable. So one has to be very careful when one claims the method for performing some medical therapy or surgery, because that will instantly be excluded. It's a waste of a claim as far as European prosecution is concerned. There are ways of looking at the material that's claimed, and then the method might actually, when looked at slightly differently, not actually have to do with the therapy itself. It might just be clumsy claim language. So sometimes your European patent attorney will be able to reword your method claim to allow you to proceed with the method claim. But other times, that will not be an opportunity. And you may want to use your 15 claims in a different way. There are other get-outs, and that may be where you could point to the fact that the surgery involves the death of an animal, so there's no treatment going on there, or where the surgery is cosmetic rather than necessary for a medical purpose. And likewise, their diagnostic methods can only be excluded when they immediately make it possible to decide on a particular course of treatment. And that can mean that some of the big data processing methods might yet be considered not to be diagnostic methods, though ultimately that may be the way the data is used. Now, novelty generally is very similar to the way things work in the States. The article involved is Article 54 of the EPC, and it has this slightly circular definition. An invention is new if it doesn't form part of the state of the art. And then we have a slightly different understanding of what the state of the art actually means. As you can see here, it's everything made available to the public by means of written or oral description, by use or in any other way before the date of filing. That does mean that the public is any person free to use the information or disclose it to another, so not subject to a confidentiality agreement, and that the disclosure itself must be sufficient for that to be considered as made available. Secret prior use is not, specifically not made available to the public in European terms. And if the invention is made available, no matter whether, get this right, an invention is considered to be made available no matter whether anybody actually saw that material. My old supervisor used to point to a document that was stored in a single library in Mongolia, written in Russian. Doesn't matter. It's there, it's public. Somebody could have walked into that library. You might be glad to know that the EPO doesn't apply an information disclosure statement requirement, but there is a certain amount of it makes sense when one is looking at the prior art to acknowledge that prior art that the examiner is going to find anyway. It just means it's an easier judgment call than an IDS statement at every 6-month point. Now, in terms of prior filed but non-published applications, the EPO has a slight wrinkle, and this is reflected in UK law as well, where something that has been filed, and it would normally be filed in the European Patent Office, will be treated as novelty only citable. So quite often that means that one needs to take steps to insert a feature that renders the claim novel, and once one's done that, the claim can proceed because inventive step is not an issue for a document in that vote. But that doesn't mean applications that are not published could indeed include international applications that are not published that have the possibility of turning into European applications. There lies a rub. So one needs to be quite careful, and quite often what you'll see a warning that a document might become something that is relevant for novelty purposes only, at which point alarm bells may ring for you. That's a subtle difference to the way that things are prosecuted in the States, particularly post-AIA. In terms of the grace period difference, the European Patent Office doesn't operate a grace period. There are exceptions in the sense that a breach of confidentiality would provide the opportunity to demonstrate an evident abuse, in which case one has 6 months grace period, in inverted commas, in which to provide that evidence and to get the application filed, regardless of what it might have been available beforehand. One has 6 months from that evidence of abuse. And you need to notify the EPO that that's what's happening. Generally speaking, evidence of abuse is either a court order saying so, or an affidavit by the party that accidentally disclosed something that they should have known was confidential. I'll remind you again that the EPO is a first to file system. So that means that we look at priority dates with great interest. I have reserved the discussion of priority in greater detail for the second part of this talk, since it has to do with slightly less common issues that arise, but just do bear that in mind. I've noted that there's no on-sale bar in the European Patent Office, nor do they have a concept of a local public use. Public use anywhere in the world is prior art. You'll be glad to know I'm going to start accelerating as we go down through the talk. That I mentioned Unity before, and Unity is essentially it's the way that the European Patent Office makes its money. It seems to me, effectively, they feel that every time one has to do a search, one has to pay a fee for that search, an additional fee. There shouldn't be the opportunity for somebody to pack in 4 or 5 different inventions in one document and have to only pay once for that. So effectively, they see it as the opportunity to charge for the work that they do. However, sometimes it does get abused. One can push against an objection of lack of unity. And indeed, one can point to there being a group of inventions that are linked to form a single general inventive concept. However, do be aware that the EPO have a habit of finding one single document that they see as knocking out that single general inventive concept a posteriori. You wouldn't have known about it, but now that they've found it, you've now got a unity problem. Nothing you can do about that. And I've made a couple of notes there about if the problem is new, then the invention can be the identification of the problem. That could be quite useful sometimes in pushing back against a unity objection. Likewise, you may see a sufficiency argument. Quite often it's bound in with the next topic, which is clarity. But sufficiency is standalone. The article responsible for this is 83 of the EPC, and the patent application must disclose the invention in a manner sufficiently clear and complete to be carried out by a person skilled in the art. So we can't incorporate by reference. Our material can't, so one has to have present in the application as filed a sufficient description. Likewise, there's no requirement for best mode in the examination of the EPO, but again, the requirement for sufficiency means that while one doesn't have to pick out a particular embodiment as being the best embodiment or a best way of implementing the invention, if you haven't described in sufficient detail and clarity, then you may fall foul of sufficiency. Years of experience with the EPO says that they don't tend to stick to a sufficiency objection. Quite often they force an amendment and then object on clarity grounds. Sufficiency is on its own is a ground that is more often than not used in opposition rather than during the examination of the case. Generally speaking, you don't get very far if you really haven't a sufficient description in Europe. And I'm aware that in the States, the AIA changed the situation around best mode, but I do believe that best mode, while it doesn't have a consequence in terms of a fine or the end of your patent, is still a de facto requirement in prosecution in the States. We would say that we don't have a best mode in Europe, but we similarly have a de facto requirement to describe what we're actually doing and why we're doing it. Otherwise, the examiner may well decide that we've been insufficient in our description, or indeed we're not being clear. I mention clarity simply because the objections to clarity happen again in every single application. Generally speaking, the EPO will comment on clarity more in those later examination reports rather than those dealing with the search opinions. But in the search opinions even, they will still point at language where, in typical US style, one has discussed the spirit of the invention. To European ears, the spirit of the invention doesn't mean anything. Likewise, the lack of doctrine of equivalence in Europe means that equivalence of claims mean nothing. Instead, we have to interpret what the claims mean using the content of the description and the figures. So they will inevitably require the deletion of any mention of spirit or equivalence. And likewise, as I mentioned before, incorporation by reference. Every time you use that word, you will either be asked to delete it because it's not essential, or to delete it and replace it by the essential piece of text. But that has its own dangers. Right, so you've received the examination report, looked through and seen all the scary objections, and then decided that actually we need to make some amendments. We have, as I mentioned before, the opportunity to make voluntary amendments up until the receipt of the search report. After the receipt of the search report and up until the response to the first substantive communication has been filed. Thereafter, one needs to have the consent of the examining division to submit an amendment. And just simply to kind of bring things back to US focus, there is no estoppel in Europe. So all these amendments and arguments that we're making during prosecution within Europe don't set a precedent at all. And it allows us to reformulate arguments and try different versions of arguments as well. We have particular parts of the EPC that forbid amendments in particular ways, and they may be slightly unfamiliar ways to the US eyes and ears. Particularly the interplay between Article 1232 and 1233. 1233 forbids post-grant amendment, whereas 1232 forbids amendments that add subject matter beyond the content of the application as filed. What that can mean is one can make an amendment, the examiner will accept it, and then you get a granted patent, And then one finds that one's granted patent, one can't amend either way to escape a problem. One can't revert to a more general version of the claim because that would be extending scope post-grant, but one can't amend back to a specific because that would be potentially you'd find oneself trapped from doing that as well. So this is the added subject matter trap that's referred to here, and one needs to be very careful. And the EPO are also painfully aware that this could happen, which is why they constantly remind us that we require a basis of support for any amendment we submit. So they have boilerplate language that they use in their letters, and they also have specific objections where they find that the particular term or passage doesn't appear to have basis. Your European attorney will also make it potentially suggest amendments to your description, and some of that can be quite alarming. We are required to acknowledge the closest prior art in the introduction to the application. Tend to do that during examination and wait until the examiner has picked out certain documents as what he feels or she feels are the appropriate documents. And then when one inserts, we should say, a neutral description of that piece of prior art, not picking out particular passages within it that are most relevant, simply pointing out essentially what was in the abstract of that application, so that that at least acknowledges its presence and that it might be considered something that is close to the current application. Generally speaking, with the EPO will ignore that in later purposes, but there have been cases where when the published version of a document acknowledges a piece of prior art, where people have tried to say that this is an acknowledgement of what the state of the prior art is, it is not limiting. Any of these changes, the EPO have particularly said that this language is not limiting, that is inserted is as if it wasn't there in the first place. It's simply to aid the reader to understand where the invention lies, if it is an invention at all. Now, I've mentioned that incorporation by reference is not allowed, but in fact, doing something like that doesn't save you from sufficiency problems or indeed provide basis for claims. Basis for claims has to be effectively literal. So if one wants to make an amendment to a claim or add a new claim, one needs to find the text, not a reference to another document in which to base that. And finally, I note on this page that the description needs to describe the technical features of the invention in detail to avoid possible exclusions. Now, I'm trying to retrieve my mouse. The claims themselves, you may see this, the EPO quite often objects to there being more than one claim in a single category. So a single method claim and a single apparatus claim would normally be allowed, but there would be exceptions where one has two different apparatus, say a plug and a socket, or a client and a server and a transmitter and a receiver. Those would be allowed as they're kind of interrelated between those two. There's a specific exception to that, which hopefully would be able to help you. But the common practice of having one method claim where one has individual steps and one apparatus claim in which there's individual components, and then another apparatus when one has means for, is deprecated in Europe. And indeed, the means plus function claims aren't limiting in scope in the same way as they would be in the States, where the means plus function, I understand, serves to refer to whatever has actually been described in the application and essentially moves away from the use of the doctrine of equivalence. You almost certainly know that Europe allows multiply dependent claims with no additional fees, as the fee is paid basically for the claim and not for the dependencies within it. Likewise, we're allowed to have claims to the carrier medium per se, rather than the non-volatile, non-transitory carrier medium only. And in terms of just the way the claims look, we tend to amend our claims so that we renumber on each occasion we file our cases, which means that we don't have this amendment, currently amended, and original prefixes to the claims in the same way as the US does. Again, a reminder that the European claims amendments tend to be very narrow, especially once we are past the voluntary amendment stage. That in Europe, one has to pay a claims fee, so one tends to try and avoid going above 15 claims. As I point out there, the euro per claim above the 15th is 235. I can't read my own writing. But once one goes to 50 claims, and I have seen this, the per claim charge is €585. The EPO quite often likes to see reference signs, that's reference numbers, in the claims, but they can be added during examination, and the European attorney will probably do that without asking you whether you need it done. Likewise, if we see non-SI units, so inches, we will convert that to centimeters without really asking you, because effectively it's a requirement. It has no limiting effect on the case at all. You'll have seen many times the requirement for two-part form. I'll leave you to consider the text there, but my standard approach is to refuse to do it, simply because one can, at least in theory, create scope for estoppel in the US, because one is making an amendment that says this bit is the preamble and therefore part of the prior art, and then this bit in the characterizing portion is the bit that reflects the invention. If one does that, then one can see that could cause problems, at least in principle, for the US. Finally, and I mentioned what the scope of the claim might be. It's worth noting that we don't have a doctrine of equivalence, but we do have an article on the protocol on the interpretation of Article 69 EPC, and that does help us a little bit in understanding what claims should, or how claims should and shouldn't be interpreted. But it's worth also noticing that when one gets to an individual court in the national offices, then the interpretation of claims changes again, so one has to take some care when we look into things. Finally, I wanted to understand, hopefully, the day-to-day work that a European patent attorney will be doing on your behalf based in the US, and hopefully you will see that there are a lot of similarities between the work that you do and that we do before the EPO. There are differences in approach. We have similar concepts of things like novelty and so on. The road to grant is different in the EPO, and to drag out the car analogy, we're driving on the same side of the road, most of us. Most of the way is freeway. We have very much the same time together driving, but we have similar signs at the same sorts of places. So I'll just remind you to watch where you park, and if you need a sign interpreted, please do refer to your European patent attorney. Now, obviously, I've missed out a whole bunch of things which have to do with, should we say, less day-to-day work, but maybe questions that come from year to year about the prosecution of patents in Europe, and where there are marked differences between that in the US and the UK, or sorry, US and Europe. And that is the subject matter of my second webinar in a fortnight's time at the same time. And it needs me nothing more to say to you guys, except thank you very much for joining me. I appreciate those people who are West Coast, that has meant that I've interrupted your breakfast. And those of you who are a little bit further east, that at least I've broken up your morning. And I would wish to thank you very much for listening and offer you the opportunity of asking any questions. I'm quite happy to take those questions through the Q&A. And I can see that there are a couple of Q&A questions that have come in. So maybe I'll answer those first, if you're okay with that, Greg.
Yeah, absolutely. Please do, David.
Thank you. So I have one question here from Stan Ross. He's asking how Brexit affects matters in terms of translations and additional addresses. I would say, well, current situation is that the UK, while outside of the the European Union, is not outside of the EPO or EPC. So everything in terms of the ways that patents operate remains unchanged. Furthermore, because the UK is outside the EU but in transition, even for those issues to do with the wider issues of being outside of the EU, those are not going to bite. And we have some uncertainty as to how things will work out in the future after the end of this year. So the transition period ends at the end of 2020. So in terms of the requirements for translations, the UK remains signatory to the London Agreement, so that if, for example, an application had been filed in German language and prosecuted in German language before the EPO, then the requirement for translation into English would only be a requirement of translation into of the claims. And thereafter, the only time you'd need a translation of the full specification into English would be if you were going to prosecute that case before the courts in the UK. It is actually part of my second webinar to discuss some of the future issues relating to Brexit. One impact potentially was, and I think maybe this is an idea for next fortnight, is we had been discussing up until Brexit vote the possibility of having what was going to be a patent that covered the entire EU, UP, it's a unitary patent, it's going to be called, and indeed a court system, the UPC, which was going to support that unitary patent. Now that is pretty much up in the air, not just because of Brexit, but also because of a decision which is still pending in the German Constitutional Court. So we're yet to hear how that will affect things, but that's for next time. So I'm going to pin that a little bit. In terms of having addresses, the address for service has always in principle been in each nation, and an address for service in the UK used to be interpreted as one in the EU, and therefore one could get away with having a single address for service to cover a number of different European states. To my mind, that has not yet changed, but it may mean that we need to have an address for service for, say, a German patent in Germany. But many of my clients already do this because that's convenient, because many UK attorneys, I'm one of the exceptions, but many of the UK attorneys don't read German, and all the letters coming from the German Patent Office will be in that language, for example. Dave Schifrin asks, where can one find a copy of the protocol and interpretation? I can dig one copy out for that, but effectively that protocol is a very short document, and it should be, I would say it's a Google search away. Certainly that's how I would get hold of it. The EPO certainly has a copy in amongst their legal documents section. In terms of, now I'm looking to other questions here. Pallavi Kondapali asks, how often do you have to amend or modify the specification with respect to sufficiency or adding technical features for those things? Effectively, the specification, you want to avoid amending altogether, but in terms of one can't deal with, we can't address sufficiency by amendment. Essentially, it's what was there in the application as filed. But during when one's drafting, if one has the opportunity to affect the draft, one can make sure that if one has something along the lines of a complete description of essentially a best mode, then one will be able to at least point and say that that particular embodiment at least is sufficient. generally speaking, sufficiency isn't, as I said before, the objection that's going to kill you. What will kill you will be a lack of clarity. So yes, it's probably there, but I can't understand what it is. And likewise, in terms of adding technical features for the computer-related inventions, if one just simply inserts by a processor, yes, one can avoid the excluded part of the thing, the Article 52 objection. But again, one has to bear in mind that unless the computer is being asked to do something which it wouldn't be expected to do, then it would be seen as conventional. So inventive step might be the issue. So adding features, simply saying in a processor or in a hardware processor, might help you in one way, but it might not help you altogether in defeating an objection. There again, one has to look for a new technical problem or a new technical solution to point to, over and above the operation of a general purpose computer. I think there are a couple of questions about the use of, I'm just bring down my chat a little bit further. Yeah, so Jean-Marie Layanouac asks about why I deprecate use of characterize in that. I simply deprecate it in the sense that I'm concerned that one could accidentally insert the words characterized in that at the wrong point within the claim. And in a claim that was designed to be a single unitary claim rather than a two-part claim, that can happen quite readily. One can leave a feature, maybe even a single adjective, in the preamble, which should really be placed in the characterizing portion by accident, and that could cause trouble. Oh, sorry, I think I may have confused Pallavi's question. So, okay, applications from the US and later applying to the EPO. Pallavi, I think maybe I'll come to your question offline and through the moderators, and then we'll maybe so that we can give you a fair answer rather than me wittering on and still not answering your question completely. But thank you very much indeed for those people who've kindly put in questions, and for those of you still with me, and hopefully Greg, you'll be there too. And thank you again for introducing me at the beginning, and hopefully we'll be speaking in 2 weeks' time.
David, thank you very much for your time, and thank you everybody for joining us.